everyone, my name is Taneva Maddox and this is my presentation on the special education law for students with disabilities. First, we will begin in 1776, 200 years after the United States was established. During this time, there was no advance in the rights for disabled students. In fact, more than 4.5 million children were denied schooling because of their disabilities. During the 1700s, students were deemed inadequate that had disabilities by the legislation for equal educational opportunities. This was a dark time for those who were disabled. The opportunities unfortunately did not start coming in until the 1970s. The 1970s were very significant in the ways of helping those with special disabilities and in need of special education. During the 1970s, the first Rehabilitation Act was granted in 1973 by the civil rights to all disabled people and required accommodation for disabled students in schools. This was a huge step for those who were disabled to have the proper education that they needed for school. The next act that was created was the Education for All Handicapped Children Act that was created in 1975 that guaranteed the rights for students with disability to receive free and appropriate education. Even to this day, these laws are still in effect for students with disabilities. Currently in the States, 91% of special education funding is provided for students with disabilities, while the remaining 9% is paid by the federal government, ensuring that the students' full total of 100% is taken care of by the government. This allows the students to get the excellent teaching that they deserve and to provide states with certain standards to encourage this teaching. Two court cases about parental rights and students' educational rights to free learning was brought forth with the case of Brown v. Board of Ed and extending Brown to children with disabilities. The Brown v. Board of Ed ruled in 1954 stopped the segregation in public schools and was deemed illegal, therefore ending a matter of law segregation based on race, disability, and the color of our skin. This case also proved that the 14th Amendment right was being violated. After the Brown v. the Board of Ed case, the first federal aid that helped students who were educationally deprived or students with special disabilities was the 1965 Elementary and Secondary Education Act. It was authorized for 1 year that allowed funding for students who were born with handicaps. Another case that preceded the Brown v. Board of Ed was the case of PARC and Mills that used the Brown's decision to specifically address the issue of education for children with disabilities. The reason this was brought up because during this time there was many more children with disabilities that were not in school and were denied public education because of their condition. In both cases, the Brown decision was used and the 14th Amendment was deemed violated, and this helped provide parents of children with disabilities specific rights to challenge and strike down state law that denied their child from the right to a free public education. Some great resources to stay up to date on the legal trends that is going on with special education is the Parenting Training and Information Centers, the Special Education Quality Assurance Regional Offices, the Dear Colleagues Letter on Education for High Mobile Children, and regulations of the Commissioner of Education Students with Disabilities, which is provided by the New York State Educational Department. These are great ways to keep up with what is going on special education children and those with disabilities and how they can be helped during this time. These are great resources to use to help aid in children with disabilities to ensure that they get the free education that they deserve despite their disabilities, and also help with funding for their schooling. All students deserve the right to a free education despite their disabilities, and this is to ensure that no child is left behind and every child gets the right to an education.